Good morning and welcome back. In this session, we shall talk about drafts and calculation of maturity date, whether it is an acceptance DC or sometimes a negotiation transaction or a deferred payment transaction where there is no draft, where there is a tenor. And we shall discuss what Isbp has to elaborate on the UCP guidance on drafts. We will discuss paragraph B1 to B18 in this session. Basics. Draft should be drawn on the specific bank. Because the LC is an undertaking or a promise by the issuing bank, normally in most of the situations, draft should be drawn on the bank, the specific bank. And the examination of the draft will be limited to whatever is mentioned in the specific article of UCP and whatever has been elaborated by Isbp that is normally practiced, and it will not be going beyond it. What it means is we will not be applying the Negotiable Instruments Act and other Stamp Act and so many things which is required in the various countries unless it has been specifically required so by the credit. The tenor of the draft should be in accordance with the credit. The tenor of the draft should be in accordance with the credit. That is, if the credit says site, it should be drawn at site. If the credit says 90 days from shipment, it should be 90 days from shipment, or it should be 90 days from invoice means 90 days from whatever it is. It should be as per the credit. When it is other than site, when the transaction is other than site, it must be possible to establish the maturity date from the data in the draft. When the draft is drawn at a specific tenor usance transaction, it should be possible to be found out as to what is the actual maturity date of the transaction or the drawing from the data given in the draft. How it is? It can say 60 days after the bill of lading date. 14th May 2013 is the date used as a sample by the Isbp, so we are using the same example. 60 days after the bill of lading date 14th May 2013, or 60 days after 14th May 2013, or 60 days after BL date being 14th May 2013, or 60 days date and then date of the draft and date of the bill of lading will remain as 14 May 2013, or straight away you can say 13 July 2013. Either of these ways the draft can be mentioned. The due date of the draft can be mentioned. All of them are acceptable, provided this gives us an idea as to what is the exact maturity date, what is the due date of the drawing from the information that is given here. The date can be mentioned as JUL or JULY or 7, provided there is some other document which gives us a clue. 7 stands for month and not date. The onboard date is deemed to be the bill of lading date. And whenever I say bill of lading date here, it also means the air transport document date or whatever date is required. And ultimately what we mean is the shipment date or the onboard date or the shipment date. The words from and after, when used to determine the maturity of the drafts, commences a day following the event. So when you say 60 days from 14th May or 60 days after 14th May, both means the count of the date will start as 14th May as day 0, 15th May as day 1. So that is how the 60 days will be counted. Days from and after means following the day of the event. When a bill of lading is presented evidencing more than one dated on board due to transshipment or board for any other thing, earliest of these dates is to be used. When there is more than one on board or when there is more than one transport document, the earliest of these dates will be taken. When a bill of lading is presented evidencing shipment on the same vessel for more than one port and more than one dated on board, the latest of these dates is used. If it is shipped on the same vessel with more than one on board, then the latest of the dates is used. If it is shipped on different vessels, if there is a transshipment, earliest of these dates is used to be the shipment date. This we have seen while we were discussing the bill of lading explanations or the multimodal transport document and other things. So in case there is a transshipment or if there is more than one on board on the bill of lading presented, earliest date will be taken. In case if it is on the same vessel, the latest date will be taken. If there is more than one set of bills of lading drawn under one draft, then the onboard date of the latest will be taken, same as this. If there is more than one on board or if there is more than one set of transport document, here partial shipment is allowed. Could be the situation where more than one vessel is there. If partial shipment is not allowed, it should be on the same vessel. If it is on same vessel, here we say the latest should be taken. If it is on a different vessel, still the onboard date of the latest BL will be taken for calculation of maturity date. The same way the latest date will be taken for calculation of presentation period also, and this latest date should fall well within the last shipment dates. So the date of the BL will have an impact on calculating the maturity, will have an impact on calculating the presentation period, and will have an impact on calculating whether presentation or the shipment has happened within the date allowed in the credit. The same principles apply for determining the maturity date or for any other basis. Instead of bill of lading, we can put any other transport document or maybe date of invoice or whatever we say. So the same principles apply. How we calculate the latest date or the earliest date, and whether how the 60 days are calculated, and when from and after is used, it commences the day after. Maturity dates. The actual maturity date stated should reflect the credit. If the credit says 60 days after, and if the draft says 13th July or whatever, it should reflect what is stated in the credit. If it says 60 days site, if it is a complying presentation, it means 60 days after the date on which a complying document has been presented. 60 days after the date on which the complying presentation has been cited. So if the complying presentation is cited today, from today is the day 0, tomorrow will be day 1, and on 60th day the site payment will have to be made by the bank if it is 60 days site and if complying. If not complying, then the presentation might have been made to the drawee bank or might have been made to the issuing bank. If it is made to the drawee bank and drawee bank has not provided notice of refusal, then it will be considered clean, and then the date of presentation is day 0, the next day is day 1, and 60th day payment will have to be made. That is, it has to be honored 60th day from 60 days from site. If no notice of refusal given by drawee bank. If the drawee bank has given refusal, then 60 days after the date, the acceptance advice of the issuing bank. Now, if the drawing is made on a nominated bank and the nominated bank has refused, then might be they would have asked the documents to be sent to the applicant's bank, that is issuing bank, or might be they would have asked to send a message saying may we negotiate in spite of discrepancies. Maybe the issuing bank took up with the applicant, maybe the applicant agreed, maybe the issuing bank also agreed, maybe the issuing bank then sent a message to the nominated bank saying we are agreeable to your negotiation of these documents subject to these discrepancies. In such a case, 60 days after the date of acceptance advice of the issuing bank would have sent this advice maybe after 20 days of the notification of this discrepancy to the issuing bank, and then technically it will become 80 days. So this 60 days will start counting after the date of receipt of advice from the issuing bank having accepted these discrepant documents, if it is done on drawee bank. If it is presented to the issuing bank and issuing bank had refused, and it is not the drawee bank that is refusing, if issuing bank is refusing, then 60 days after the date, the issuing bank accepts the waiver of the applicant. The applicant may or may not accept the discrepancies. If the applicant accepts, the issuing bank may or may not accept the discrepancies. If the issuing bank accepts, 60 days after the date, the issuing bank accepts the discrepancy acceptance by the applicant. So it will be calculated 60 days after that date, and then the non-complying presentation will become due for payment. The drawee bank is to advise or confirm the maturity date to the presenter. If the beneficiary is presenting to the nominated bank has to tell this is a maturity date on which we will make payment for this transaction, whether it is sight or use hands. This calculation method, the 60 days for complying and non-complying, applies to acceptance DCs, deferred payment DCs, and negotiation DCs. Whether draft is done or not, it applies suitably as applicable or if applicable to acceptance DC, deferred payment DC, and negotiation DCs. The 3 types of availability that we have: banking days, grace days, and days of remittance. When we say a maturity date, in the above example, we have seen 13th July, 60 days from 30th May, we have seen 13th July is the maturity. When 13th July is the maturity, the payment will have to be made on 13th July, irrespective of number of days it takes to remit the funds, number of days it takes for the funds to reach. Number of days it takes for the funds to reach the ultimate beneficiary. So payment is to be made by whoever is paying by immediately available funds. They should not pay in a form which cannot be converted and used. That is, there should be liquidity of the funds, immediately available funds. It should be paid on due date, and it should be paid at the place where draft or documents are payable. So if LC is available in Moscow, the payment should be made, or the funds should be made available on the due date at Moscow on immediately available funds. You should not pay in a currency in Moscow which could not be used by the banks in Moscow. So that is what it should be: immediately available funds, not under reserve or not available but cannot be withdrawn types. On the due date, it should be available there, and it should be available at the place where drafts are payable. Place where drafts are payable is a place where the LC is available, where honor is to be done. If the due date is a non-banking day, payment is due on the first banking day following that date. If the due date is a non-banking day, because when you calculate 60 days after the date of a particular event, and if that falls on a non-banking day, payment is due on the first banking day following that date. So that is why what happens is, when the bills are drawn on banks in Middle East, and when they have 1 week long holiday for Ramadan or Eid and things like that, the payment will be delayed by that much period till the first banking day is available, and then the funds will be paid. Many times what happens is, the country of drawing the country of issuing bank and the country where reimbursement is being made may be in different places, and they may all have holidays, and so the payment will become due only on the banking day on which this currency or the reimbursing bank is working to make the payment. And ultimately, even if it reaches the beneficiary country, it may not be available for them because it may not be the banking day on which it is received. So the next following banking day, they will be able to utilize the payment or settlement made. Grace days and other delays are not in addition to this date. Grace days and delays or other time taken for remitting these funds all are included in this 30 days, 60 days or whatever. Pre-debit notification, pre-notification, everything is included in this date, and this 60-day period or the maturity date will not be extended because of the grace day or any other delay caused in remitting the funds. Let us have a look at the drawing and signing of the drafts. The draft should be drawn and signed by the beneficiary. The draft, when called for under the credit, should be drawn and signed by the beneficiary. It should indicate the date of issuance so that we can calculate the maturity dates. It should be on or after the date of LC, definitely, because all documents has to be like that. But draft cannot be dated after the date of presentation. Most of the documents cannot be dated. Beneficiary or the second beneficiary, if they have changed their name, if the first bene has changed their name or the second bene in a transferable LC has changed their name, they can draw it in the name of the new entity and state formerly known as. If drawee as per credit is a SWIFT address, if the LC is sent by SWIFT and the SWIFT field in the drawee field is mentioned only the SWIFT address, for example, HSBC US 33 is HSBC in New York, then the draft can show the SWIFT address or draft can show the full name. It can say HSBC US 33, it can say Hong Kong and Shanghai Banking Corporation New York, it can say Hong Kong and Shanghai Banking Corporation New York, post box number, zip code, this, all the full details. It can show either ways, as long as this does not conflict with the credit and this is an expansion of a SWIFT address, it is acceptable. If the draft is available by negotiation with the nominated bank, if there is a nominated bank nominated by the issuing bank, and if it is available by negotiation, draft is to be drawn on a bank other than nominated bank. If the LC is available by negotiation and if a draft is called for, it should be drawn on a bank other than nominated bank, because the nominated bank will be able to negotiate only documents not drawn on them. If a draft is drawn on nominated bank, they will have to honor the draft but cannot negotiate a draft. To enable them to negotiate a draft, the nominated bank should not be the drawee of the draft. If it is available by acceptance with any bank, then draft should be drawn on the bank which is willing to agree as per the nomination. So when it is any bank, you don't have a specific bank. It can be HSBC in Chennai, it can be Standard Chartered in Chennai, it can be ICICI Bank in Chennai, it can be State Bank of India in Chennai. So it should be drawn on the bank which is willing to act on the nomination when the credit says any bank in and payable at Chennai. If the credit is available by acceptance, this is a negotiation, this is acceptance. If the credit is available in acceptance and if the nominated bank decides not to act on the nomination, suppose it is available with a bank called National Commercial Bank, and if the bank is not willing to act as per the nomination, then the beneficiary can request the documents be sent as it is to the confirming bank, request the documents be sent as it is to the issuing bank, or they can draw a draft on issuing bank or confirming bank and then send those documents, or the beneficiary can present this to any other bank which is willing to act as per nomination. If the credit is available by acceptance and if the nominated bank is not willing to act as per nomination, the beneficiary can withdraw those documents and present to another bank which is willing to act as per nomination. Or without withdrawing the documents, it can as it is ask these documents to be sent to the issuing bank or confirming bank. Or the beneficiary can replace the drafts with a draft drawn on the specific issuing bank or the confirming bank and then ask the documents to be sent across to them for honor. If the presentation is non-compliant and the confirming bank decides not to reinstate the confirmation, this is a nominated bank. Here, if the confirming bank is not willing to reinstate the confirmation, then they may draw a draft on issuing bank and ask them to send the new draft and the documents to the issuing bank, or need not draw a draft but ask the non-compliant documents including the draft on confirming bank to be sent to the issuing bank for honor. In any case, issuing bank will have to honor if it is a compliant presentation. Amounts. The amount drawn for under the draft should not exceed the amount on the credit. It should be the amount on the draft should be the amount of drawing made. The covering schedule or the invoice or other things, if they are having different amount and draft is having a different amount, then the amount on the draft will be considered as the amount of the drawing. The word in figures and the amount in figures and amount in words should not be in conflict, and if it is conflict, the amount in words will be considered to be paramount. Endorsement. It should be endorsed if necessary. If it is drawn to the order of a party, then it should be endorsed so as to make it available by endorsement and delivery, the title of title transfer. Correction and alteration. Any correction on draft, if allowed in the country where the transaction is to take place, then should appear to have been authenticated by the party who is drawing the draft, who is the drawer, the beneficiary, the supplier. So the beneficiary of the LC, when he draws a draft, and if he finds there are any corrections or alterations, they have to authenticate it. How it has to be authenticated? By signature or initials, provided corrections in draft are allowed in the jurisdiction. If corrections in drafts are not allowed, then LC has to so indicate that corrections are not allowed, and if there is any correction or alteration, authentication is not adequate, and a fresh draft will have to be drawn. Drafts drawn on applicant. Credit should not be issued available by draft drawn on applicant. Credit should not be issued available by draft drawn on applicant. But if still the applicant and the issuing bank insist that there should be a draft drawn on the applicant, it will be examined only to the extent expressly stated in the credit. Credit has to give in detail what should be examined, whether these articles and these paragraphs of Isbp will apply to examination of that particular draft drawn on applicant, and if nothing is mentioned, article 14F will be the one that will apply to the examination of such drafts drawn on applicant. So thanks for watching this video. We shall meet again on another session on another topic on Isbp.